HIPAA sounds big, scary, complicated, but does it really do what you think it does? Maybe, maybe not. So, buckle up for a HIPAA 101. Hey y'all, welcome back to #Lawyered. You have Austin and myself live in studio, chattering at you while you're in the car, your AirPods, whatever. Happy you're here to listen to us.
About HIPAA.
About HIPAA! Not a hippo, although they're kind of cool. Did you know actually hippos are like really dangerous? I was reading an article. I didn't. I thought they were sweet, friendly creatures. Lies. They're extremely violent, and the amount of deaths on the Nile caused by hippos is like strangely high.
They're very aggressive. Yeah, that's actually, I learned about that, and that's part of the reason that Pablo Escobar had his pet hippos, because he admired how aggressive and violent they were.
I had no idea. Did he keep them in like a moat around his compound?
Well, in the show Narcos, it looked like he did, but I haven't really researched the validity of that part of it. I know he had pet hippos.
Mexico edition
Colombia.
of Narcos? Oh.
No, well, it was in the Mexico. The scene with the hippos was in Narcos Mexico, but the scene was shot, portraying Pablo's compound in Colombia.
Interesting. I don't remember that scene, but I also watched it in Mexico late at night, and so that was probably a bad idea, and I was probably scared. That's why I don't remember it. But anyway, back to HIPAA. We're leaving the hippos.
I think one of my favorite things about, when I read the outline, I thought about this, because I've said this on the show before. I've quoted Princess Bride, where there's a part where he says, "This word you keep on saying, I do not think it means what you think it means." It's exactly what we're talking about here today with HIPAA.
Yes, that is extremely on point.
Thank you.
Yeah, look at you. All right, so HIPAA, literally, it's an acronym, right?
Yep.
Okay, so literally HIPAA stands for the Health Insurance Portability and Accountability Act of 1996. So like way back in the day.
Yep.
I was 5.
I was 10.
Wait, you're that much older than me?
Yeah.
Oh, whoa. I thought you were only like a year older.
No, I'm 34. About to be 35.
Okay. That's cool. So anyway, but overall, HIPAA is not just the 1996 Act. There are also several acts now that work with and are complementary to HIPAA, so that when someone says HIPAA protects me, they're also in general referring to these other acts.
Right.
The most salient of which at the federal level is also known as the Omnibus Final Rules, which were promulgated by the U.S. Department of Health and Human Services, made effective in, I think, February 2013.
Yeah, and omnibus, we hear this in law all the time, and it's kind of a weird word.
It's Latin.
So, okay, do you know what it means in Latin?
I think it means like of all things.
Okay, because it really, when I read it, I think it just means like all-encompassing. It's kind of, let's wrap everything up, put it all together.
Means all, and then I think the ibus is like the genitive form, so I think it literally translates to of all things. But I haven't read like actual Latin or translated Latin since college, so don't quote me.
But the context of it makes sense, because it's the Omnibus Final Rules in 2013, they're taking a bunch of all these things and throwing them together and say, all right, here's our universe of everything.
And the reason that this had to happen, right, is because in 1996, I mean, what was the internet then?
Right.
Was there even internet? I don't know. I'm too young to remember.
I'm not sure if there was. I just know that was the year the Cowboys didn't make it to the Super Bowl to make it the 3rd year in a row.
Forever scarred, aren't you?
That's just, a lot of times in my childhood, I equate years of time with years of Cowboys Super Bowl wins and NFC Championship losses. So
true fan right here. Yeah. Cowboys, you hear that? He needs a jersey. Anyway, so this act was before the internet really got up and going and savvy. So clearly there need to be things that took into account the internet and email.
Sharing information.
Data
security.
Data security is a big one.
Big time.
Which is one of the reasons that the Omnibus rules were promulgated, because in 2013, the internet is a huge thing.
Right.
So.
Makes a lot of sense.
But anyway, going back into it. Texas does not want to be outdone.
Of course not.
Of course not. God bless the Lone Star State, y'all.
Yeah. And I say that with real pride, not sarcasm. So.
Oh, okay. Sometimes I can't tell.
Well,
you and Spencer have the same issue.
That makes sense.
Yeah.
Just keep you guys guessing.
Okay. Well, it works. So, so anyhow, Texas does have its own complementary laws to HIPAA, right? So it's the Texas Medical Records Privacy Act, effective September 1st, 2012. If you want to be super cool and academic, you can look up the law and read it.
Is that super cool? I think that's just academic.
I think it's just academic. I'm trying to be supportive of academic
That's okay.
research.
I apologize.
Okay.
Nerd.
That's true. And so anyway, it's located in the Texas Health and Safety Code section 181.01 and subsequent.
Mm-hmm.
So there you go. You can look it up.
And so I think, one of the things, and this was helpful for me because everybody, and I'm guilty of this too, throws around the term HIPAA anytime you talk about anything healthcare, medical related, whatever. But actually, as we're about to dive into, it deals with 3 categories, right, of information.
It does. So, and we're just going to keep this discussion very broad, 10,000 foot view. You're welcome. Maybe if we're lucky, we can get my friend Martin Merritt onto the podcast later to go into some more niche areas, because that is all he does is healthcare law.
Yeah.
So he's like the king of healthcare. But anyway, so HIPAA protects sensitive information in medical records. Okay, right? That's the primary thrust of HIPAA. But it does protect some obvious information, but then there's also some information that it does protect that you wouldn't think of as being sensitive health information.
Okay.
So first of all, it doesn't necessarily protect the entirety of the medical record in of itself.
And that's a surprising thing to most people.
Yeah. It protects certain information in the health record, which could make up most of the medical record.
Sure.
So you can get a document and it can be tons of redactions with a few words here and there. But anyway, so in general, there are 3 types of sensitive information in medical records, right? So the first one is super obvious. It's the information about the patient's health.
Right.
So, for example, Joanne is pregnant, or Dylan has swine flu, or Lola got diagnosed with type 2 diabetes, or someone is diagnosed with an STD or whatever, right? I mean, very sensitive medical information.
Well, and that last example, that's part of the reason that in personal injury cases, a lot of times the plaintiff who is injured is not okay with, and his or her lawyers are not okay with just opening up and sharing all medical records, because there could be some embarrassing things that have nothing to do with the car wreck, workplace accident they had, and all those kinds of things. And HIPAA helps protect some of those things.
It not only helps protect that, but actually under HIPAA and then the subsequent laws enacted to complement the original 1996 Act, there are now, including the Omnibus rules, possibly sanctions that can be levied against attorneys who are not super careful about producing medical records in a safe way, right? So you have to get medical authorization before you can release this medical information. And, you should be making sure that you get an agreed protective order with the other side, meaning that this information can only be shared with the court under seal, right? So basically it's not posted on the online docket. It's not publicly available. It's only available to the court, portions to the jury, if it goes to trial, the lawyers, and then the experts to a degree.
Sure.
And so in violations of that means bad news bears for the lawyers.
Yeah. Yeah, and we'll get into that.
And we'll get into that. But anyway, the second type of thing that is protected, right, is in a medical record is going to be your basic financial data, like
your social security number, your credit card numbers, date of birth, which, as you point out, is a gold mine for identity thieves.
Yes.
And so actually, you don't think about that as being HIPAA, but when you mention it, it's well, yeah, of course that's there. That's really good. We should be protecting that.
Yeah, absolutely. We need to be protecting that. I don't need my credit card that I pay my copay with when I go for my checkup to be, flashed around the world.
Yeah, exactly.
And then the third thing, and I think a lot of people don't really think about this, is the chart that contains all the different diagnoses codes.
Right. People
look at it and they're like, what is this gibberish? It's DON37 or something like that.
Yeah.
What does that even mean? Well, if you're a sophisticated healthcare thief, you know what these things mean.
Right.
And that can also be a gold mine.
Yeah, absolutely.
So, this chart also contains diagnoses codes. It also contains health insurance plan IDs. So Blue Cross Blue Shield, ZGP 12798.
Your group number, your identification number, your policy number. Yeah, those
maybe a Medicare number.
Yep.
And so this is really valuable to sophisticated thieves, because if they steal just one identity, say they steal Erica Smith, okay, now that they can put in claims for, hundreds of thousands of dollars for going over various medical services, right, for just one individual, and then get money that way.
Right.
And that is not cool.
Right. Well, and so again, it's all this makes sense, and so where we talked about or in our pre-show discussions, we talk about there's an expectation of privacy, and where does this come from?
Right.
That
So
leads to these HIPAA laws that we have.
Yeah. So the reason that this protected health information, or PHI, right, is all protected in this expectation of privacy, it all stems from the police power reserved to the states under the 10th Amendment.
Right.
Not to like completely oversimplify 225 years of constitutional history and case law, but that's essentially where it comes from. Which is interesting, right? Because when Congress originally wanted to give HIPAA teeth, there wasn't a lot of teeth in 1996.
Mm-hmm.
It wasn't such a big deal because you didn't really have the internet.
Right, the proliferation of possible thieves probably wasn't out there as much.
It wasn't
it's
as
so
much.
easy digitally to do that now.
And now it's really easy digitally to, well, I shouldn't say really easily digitally. It's possible to break into someone's email and steal their health records.
Yeah.
So we'll get into it later, some tips and tricks for people who deal with health information. But for example, don't email your attorney your health records in non-redacted and unencrypted form.
Right.
Like hand deliver it.
Right.
Or, your attorney will most likely set up a document retrieval system that has encryption for you to upload to.
Right. Provide those safe measures like we talked about.
Yeah. So that your information is safe and not open to thieves.
Right.
Anyway, where was I going with this?
Well, we said that it's reserved to the states to promulgate laws that regulate these types of things, like Texas did, like we talked about earlier.
Like we did. So Texas did that earlier. So this is interesting though, right? Because so this expectation of privacy comes from the police power reserved to the states, which means that when Congress wanted to give HIPAA teeth, it knew it was going to run into issues because now there's this balance between federal government and powers reserved to the states. There's this battle. They go back and forth. So Congress is like, look, we know this is not going to work out for us. This is going to be a hard time. We're not going to have a lot of teeth in this bad boy once it passes, if we try to pass a new version of HIPAA at the federal level. So wisely, they give themselves a limited amount of time to create a new toothy HIPAA. Failed because there was gridlock, couldn't get things done, of course.
Right.
So they bounced it at that point to the U.S. Department of Health and Human Services, or the Office for Civil Rights of the U.S. Department of Health and Human Services. And they're the ones who promulgated the final omnibus rules that we mentioned earlier that were effective in February 2013.
Yeah, makes sense.
So it's not a law the same way that HIPAA of 1996 is, but it, for all intents and purposes, is. Because there are still severe penalties for failure to abide by the omnibus rules.
Yeah, and that's kind of what happens when you've got something like HIPAA or like something else that's regulated by a regulatory agency. You've got penalties, fines, things like that are usually what you see more of than just arrests or lawsuits and things of that nature.
And frankly, I think it was better that it bounced out of Congress into the Department of Health and Human Services, because these people are actually experts within the healthroom field.
Exactly.
I would rather someone who's an expert in healthcare be determining what rules are necessary to protect my PHI, as opposed to, someone who is a representative from Texas that maybe has always done, I don't know, patent litigation.
Yeah.
I mean, how much do they know about healthcare?
Right.
Not much.
Yeah, exactly. And that's the benefit of having regulatory agencies, because they are experts in the field.
Absolutely. So anyway, now that we've talked about this and we've kind of have an understanding about where HIPAA comes from, I think a lot of people think that HIPAA gives them causes of action as individuals if their information is leaked.
Right.
So for example, we'll give an example where attorneys are the bad guy.
Yeah.
Adam's a PI attorney. And
personal injury.
Thank you. Okay, so he is working up Pam's case. Pam has a slip and fall at Walmart.
Yeah.
That can be a big money case.
Yep.
So he's working on the case. He leaves all of Pam's unredacted medical information, all of it, scattered on his conference table.
Yeah, so these are treatments from her chiropractor, the spine doctor she went to, the ortho doctor, her x-rays, the diagnoses, the money, the bills that she paid with her credit card, all those things.
All of these things.
All PHI.
All PHI. Gotta love those acronyms. Alphabet soup situation, And then you've got, Terry the thief, who shows up. He's kind of like a ninja.
Terry, I like that. Terry the thief, nice.
Terry the thief. He's going to be a recurring character. Shows up, when everyone leaves for lunch because, Adam forgot to lock the office door and the secretary had to run and take a call. And so for 5 minutes, there was no one there in the office. Dun, dun, dun. Terry the thief comes in, swoops up all the information, jets out of there. And then now he's stolen tons of protected PHI that belongs to Pam.
Yep.
Pam finds out. And she is not happy because she's getting all these charges on her health insurance. And she's like, why is Blue Cross Blue Shield saying I put in for this, this, and this, and this health service? I mean, these are hundreds of thousands of dollars.
Yeah.
And then she finds out what happens. And Adam's like, oh, frick. And she's like, I'm going to sue you for violating HIPAA. And Adam's like, ha, you can't.
I don't know. That shouldn't be his response, but
that should not be his response.
He's right. You can't sue for violating HIPAA.
Yeah.
She can report him, and
she can report him.
He may be fined or have some disciplinary action taken against him. That can be from the Board of Law Examiners or through the HIPAA regulations as well.
Or
probably
it could
both.
be, yeah, it could be the regulatory agency, associated with the Office of Civil Rights.
Yeah, and that's what I was really getting
OCR.
at. Yeah,
Office of Civil Rights. And so that's the thing, though, is that people think that they have individual causes of action to bring against like a hospital, an attorney, a nurse, a midwife, whatever that releases this PHI. They don't. The person who is standing to hold individuals accountable for violating HIPAA is actually the government.
Yeah.
So report them, and that'll probably be enough.
Sure.
But you don't have standing to sue them individually.
Right, exactly.
Yeah. So, and then, like we said earlier, I mean, this can include fines, injunctions, disciplinary actions, and then if you're in trial, right, you go to trial, it could possibly lead to the exclusion of evidence that you obtained in violation of privacy laws.
Yeah,
so
I always forget about that one.
Yeah. So if your a defense attorney obtained like medical information without going through the appropriate medical authorization, okay, that could actually be excluded at trial.
Yeah,
possibly.
Makes sense.
Anyways, so 3 hot tips for people who are beholden to HIPAA and handle medical records. 1, if your employee loses her iPad, and that iPad has information on it affecting more than 500 people, the HIPAA breach notification rule is triggered at that point. And this one's really interesting because when that breach rule is triggered, the employer then has to report that breach and that loss of all that data to the leading newspaper in the area.
So that's crazy.
Can you imagine?
That just sounds crazy to me.
It's wild, but it's so that people are aware that their health information
sense.
has been leaked.
It makes sense.
And so how embarrassing for the employer, right?
Yeah, absolutely.
So like people like really need to drill down and be like, hey, if you have PHI on work provided tablets, iPads, even on your cell phones, like you really need to keep that stuff under lock and key, man.
Yeah, and that's
Don't
the reason
jack
like
it.
remote in and those kinds of things is really the way that's one of the ways you need to use. One of the methods you need to use to protect HIPAA, because then it's not necessarily on the iPad. You got to log in through a VPN to remote.
But you also have to be careful of that because remember the Colonial Pipeline episode?
That's true. Yeah.
Yeah, the hackers figured out someone's remote login and got in that way.
Yeah.
So be super careful, y'all.
Right.
And have a crazy strong password for your remote in. But anyway, so tip number 2. Oh, actually point number 2 for the breach notification. A lot of people think it's like Terry the thief coming in, stealing the iPad. Actually, most of the time it's because the device is just lost.
Yeah, that makes sense.
Yeah, so it's just someone was careless.
Sure.
No Terry the thief. Okay. And then point number 2. If you only need like HIPAA information for a limited period of time, so say, for example, you are an attorney. Well, you are actually an attorney. We both are attorneys.
Yes.
Okay, so say that I have a client and I'm dealing with their HIPAA information for a PI case. Okay. I'm only going to keep, first of all, I'm going to make sure all copies on my system have all PHI redacted. And then once the case is over, I'm going to give the client, the option of, hey, do you want your files back digital and or hard copy? And then once I do that, I'm going to tell her, okay, in 30 days after I give this to you, I am deleting everything that has PHI from my system and I'm shredding all hard copies.
Yep.
You are warned. This is my protocol. Take your stuff before I get rid of it because I don't want to risk a data breach.
Yeah, because then if there's a data breach, guess what? You already got rid of it.
Yeah, I already got rid of it. What are they going to do? They're going to click on the file folder and be like, Plaintiff Pam, aha. Oh, it's empty.
Yeah, exactly.
Except for like maybe some pleadings that are all public record that don't contain PHI.
Right.
Okay, then I'm safe.
So that's definitely a smart way to do it.
And then third.
The easiest one is don't email unencrypted medical records, especially when they're not redacted. And so
Mm-hmm.
two things: encrypted, it's an extra level of security. I don't understand it. I just know that it provides
Whizzes do.
provides extra security and
Mm-hmm.
it keeps people from getting into it. And then redacted, we keep using this word. I think we hadn't really defined it yet, but it means you black out or you white out the information where you can't see it on the document. It's literally just a cover.
Yeah. And normally I do that on Adobe PDF where it actually like removes the text and just inserts like a black rectangle in there.
Yeah, that's what I do too.
Because if you just use a Sharpie on like regular paper, you can actually, if you hold the paper up to the light, you can still see the words in the back.
Yeah.
So that's not good. Don't do that.
It's a little on the job tip there.
On the job tip. Yes. Okay. But let's make this a little bit more interesting. Let's talk about COVID and HIPAA and COVID vaccines.
And I think, hopefully we can get somebody on here to talk more in depth about the lawsuits that have come up. So
I do think that's interesting.
We'll probably keep it kind of surface level here on this episode for hopes that we can get more in depth as those lawsuits progress more. But the interesting thing that researching this pre-show that I didn't realize, because this is the thing that people talk about all the time, is that HIPAA really doesn't apply to the question of your employer asking whether or not you've had the vaccine.
Which is really interesting when you think about that.
It is. And the reason it is because it doesn't actually apply to looking at medical records that have this PHI in it.
Because you're not handling PHI, you're not handling the actual record, you're just asking verbally, have you obtained the vaccine? And I think this also plays into the fact that, contrary to popular opinion, private employers can require you to, as a condition of your employment, receive the COVID-19 vaccine or one of the vaccines.
They can. And it goes back to something we've talked about in First Amendment context. If you don't want to do that, then you don't work there. You go somewhere else.
Yeah, there's, this goes all the way back to, I think, smallpox inoculation, which is wild. But I mean, there's a case, and my husband spouts it all the time to people who are anti-vaxxers who are like, I have a constitutional right not to be vaccinated. Well, no, you don't.
Yeah.
Because
unfortunately, you don't have that choice if that's what
you don't have that choice, right? Because way back when there was a case where I think it was up in like Maryland or I don't know, like a northeastern state, maybe Massachusetts, smallpox outbreak, and I think it may have been in Boston, and the government required people to be inoculated against smallpox in order to control it, because I mean it's a pretty deadly disease,
right?
And so that set the precedent of, if it's within the greater good and all these different long list of variables and factors are met, the government can require you to be vaccinated if you're going to be like out in public using public facilities like the public schools and things like that.
Yeah.
Employers, even less restriction.
Right, because it's a private company.
It's a private company.
And so, they can ask whether you've had the vaccine, not protected by HIPAA. Now, after that, what I find is interesting, and this hasn't really been tested yet. These are more just kind of regulatory opinions that are giving some guidance on what you should or shouldn't do. Asking about why you didn't get the vaccine. Now, after that it opens you up to the Equal Employment Opportunity Commission talks about the fact that you could open yourself up to discrimination lawsuits and other problems if you then start asking deeper questions as to why you didn't get the vaccine and delving into that.
But the thing is on the flip side, if your employer asks you whether you've gotten the vaccine or not, and you say no, and they say, okay, I understand. So just to let you know, if you choose to get the vaccine, we will give you an extra week's worth of paid vacation and time off. They can do that.
They can do that.
They can do that. They can offer incentives. And a lot of people are going to say, well, that's basically discrimination, because if I don't get it, because I think it, is unconstitutional and I just don't want to get the vaccine, well, that's not discrimination. And
it's not really, I mean, there's some employee wellness programs that offer extra benefits and in their compensation package for people who lose a certain amount of weight during like a wellness push,
Yeah, absolutely.
They're allowed to do it. Private company incentives, they're allowed to do those types of things.
Absolutely. Yeah. And so I think a lot of people have this incorrect concept that their constitutional rights are greater than they really are when it comes to vaccines.
Yeah, I know. They do. And the other interesting thing about this is that it really goes down to the base of HIPAA. HIPAA was designed, and you said this a few minutes ago when we started talking about the COVID the vaccine. It was designed to protect and police the people that are handling this information, medical providers, lawyers' offices, the people that are dispersing this information back and forth. They're the ones that the HIPAA was really designed to protect. It wasn't designed to prevent the question of did you get the vaccine or not.
Especially when it's asked verbally.
Right.
And there's no record of it.
Right. because it's trying to protect against this information getting out to the public. So if they were to share your medical records that had your vaccination history on it, okay, now we may be talking about something.
Like, so for example, I got the Johnson & Johnson shot. And so if I had turned in my J&J like CDC shot card to my employer and then they leaked it, which they never would, that would be a HIPAA violation.
Now we got HIPAA issues.
Now that's a HIPAA issue.
Right.
Because it also has like my date of birth on there and like things like that. Okay. But for my employer to ask me, did you get the vaccine? Totally fine.
Right.
And I think this is really interesting because we saw this play out at, was it like the Methodist Hospital down in Houston?
Yep.
And there was a really big brouhaha because the hospital was requiring its employees to become vaccinated. I'm sure they probably had exceptions for like if you have an underlying medical condition that makes it dangerous for you to get the vaccine or you have a religious exemption, like if you're a Jehovah's Witness, you can't get vaccines, right?
I have no idea.
I think maybe that's a thing.
Yeah, but they did require.
But they did require, with, of course, I'm sure they probably had exceptions. They did require on the whole that you got the vaccine. And a bunch of employees were terminated, right? Yeah. They were terminated or they left because they wouldn't get the vaccine.
Right. They filed a lawsuit. I believe it's been 12B6. I think it's been dismissed because of because of what we're talking about here, the private employer, and especially because it's a Methodist hospital. It's it's
super private and it's a religious institute.
Right.
Well, a religious affiliated institution.
So it's not funded by. It's not a public institution that's run by the government like Parkland, County Hospital.
Yeah.
So even outside of that, even more, they're allowed to do those things. And if you don't want to do that, you got to go work for another hospital.
And to be 12B6, I mean, that's a federal rule of dismissal, basically saying that your lawsuit is worthless. There's no plausibility in it.
Right.
And so that's pretty bad to be 12B6'd out of court.
It'll be interesting. I think we'll see some more creative litigation spin up about this, and it'll be interesting to see. And I can't sit here and imagine because this isn't my field, but I can. I'm sure there will be some cases that come up that are more unique, that have some fact patterns that maybe keep it in play, so that we get to see how they turn out, and hopefully at that point we can get your guy on here and maybe have some more in-depth discussions about it. Because that'll be interesting.
That'll be really interesting, and I'll be interested to see when the vaccine becomes available to very young children. Because I think right now the youngest for at least one of the vaccines is 12, 15, something like that. When it hits elementary school age, I'm very interested to see what happens there.
Definitely.
Yeah. My theory is that it might be required.
Yeah.
And not much you can do about it.
Yeah.
Anyways. So, HIPAA. So fun. Yay. Non-hippos.
Yeah. Well, and hopefully we demystified some of this stuff and people understand people at least understand how it applies so that they're not using it in terms that don't actually apply.
So, y'all, thanks for hanging in there with us and listening to your HIPAA 101. And we'll catch you next time.
Guys, thanks for listening. Closing arguments are coming up, but make sure before you go rate, review, and subscribe to our podcast anywhere that you listen to your podcast. Check us out on YouTube, and you can check us out on Instagram and talk to us, tell us what you want to hear about. You can search us at #Lawyered, spelled out. You can talk to Andrea at andrea.s.turner, and you can talk to me at The Dallas Lawyer. See y'all again soon.
Well, another Kardashian closing argument. Tristan Thompson, Khloe's baby daddy, just got a nice chunk of change against his paternity accuser, Kimberly Alexander, who was claiming that he was her baby daddy too. Well, turns out someone got a default judgment, and Tristan Thompson now has been awarded a nice chunk of change against his paternity accuser. So, lessons learned. Always avoid default judgments and be careful when you make a libel claim.